I think it might be time to kick off. I'm Professor Jane Kay, for people who don't know me, and I'm in the Faculty of Law at the University of Oxford. I would really like to welcome to the second seminar in our series on law and technology. The person who's actually organised these series is Dr. Michael Morrison, and so I'm going to hand over to him to introduce our speaker. So
thank you, Jane. So our speaker today is Professor Emilie Cloatre from University of Kent Law School. Emilie, very interesting scholar in that she combines strong legal research with insights from the socio-legal tradition, in particular drawing on science and technology studies. And in fact, Emilie has both a master's in law and a master's in kind of research methods from the University of Nottingham, as well as her PhD. In her PhD work, she looked at the impact of the trade-related intellectual property agreement on access to medicines in countries in Africa. And that research and subsequent research that went on to inform her 2013 book, Pills for the Poorest, Access to Medicines in Sub-Saharan Africa. She's also been involved with another book in 2014, which was co-edited with Professor Martin Pickersgill at the University of Edinburgh. And that book was entitled Knowledge, Technology and the Law, and that examines some of those intersections between legal scholarship and scholarship around technology and innovation. So the research that Emilie is going to be presenting to us today, it draws from her current Wellcome Trust Investigator Award, which is entitled, sorry, I will have to read it out because there's quite a lot of the title, which is entitled Law, Knowledge and the Making of Modern Healthcare, Regulating Traditional and Modern Medicines in Contemporary Contexts. So on that note, I'm going to hand over to Emilie. I think we're all looking forward to this.
Thank you very much, Michael, and thank you to you both for the invitation. So as Michael mentioned, the paper I'm presenting today is based on this larger Wellcome project. And the project looks at the regulation of alternative and traditional medicine in a number of case studies in Europe and Africa. The aim of the project as a whole is to look at the kind of dilemmas that states face when trying to regulate practices that sit on the edge of science, and sort of stand at the crossroad between medical and sociocultural practices. Looking at this also enables us to think about broader questions around the interface between law and science and law and medicine, and to interrogate the everyday precarity of practices that often stand on the border of legality and illegality. So in this paper today, I want to look at the example of the regulation of traditional healing in Senegal, which is one of our case studies, to interrogate some of these issues and some of these dilemmas. The paper is based on empirical research conducted in Senegal since 2018, by myself initially, followed up by a local team of researchers. So the paper will be co-authored in its final version. It's primarily based on semi-structured interviews with the key actors of the regulation of traditional healing and on some documentary analysis. So in November 2017, a legislative proposal on traditional medicine was brought to the Senegalese parliament. Very soon after, within a few days, the Biomedical Council, publicly expressed its opposition to such a proposal in the strongest possible terms, with a very sort of heavily mediatized press conference in a sort of very public way. The text became the focus of a legal and an epistemological controversy that is still ongoing today. The text has not been adopted. It's not clear whether it ever will, but it continues to animate conversations among doctors and among traditional healers, fueling tensions that have been ongoing for several decades, and that hinge on the core question of whether and how traditional medicine should be regulated by the state. And if so, who should be entitled to triage good and reliable healing for practices that are deemed unhelpful, problematic, or unproven? In this paper today, I want to chart the context in which contemporary legal debates around traditional healing in Senegal unfold, pointing in particular to the type of power-knowledge relations that are at stake in both the current legal system, the status quo, and the proposed changes. I interrogate the struggles of a legitimacy and recognition that are at play, and the ways in which different actors relate to legalities, both as formal legal processes and as a more abstract notion of quasi-law, let's say, in which imaginaries of the law, lay understandings, negotiations with the law translate into everyday practices. In these processes, legal and scientific discourses are mobilized to draw the opportunities and the boundaries that are offered to different kinds of healing practices. And they're used to organize their respective authority and sphere of practice. Traditional healers overlap with modern healing practice and with modern health practices, while retaining their own ontologies and claims to legitimacy. So just a little bit of background first on healing itself. So like many other states in West Africa and in Africa in general, traditional medicine has a very long history in Senegal, and healers continue to play a very important role in everyday access to healthcare. They're often the first point of call for a number of people. Since the 1990s, it has also been at the center of various governmental policies marked by an emphasis on the need to modernize healing, aligning it more firmly with scientific evidence, adapting its practice to the requirement of modern healthcare. But like elsewhere, the everyday of traditional healing in Senegal also offers a very diverse picture, mapping partly onto the significant religious, ethnic, and geographical diversity of the country, while also being affected and adjusted through the practice of each individual healer. While some healers share the government's idea that the scientific potential of traditional healing needs to be harnessed, others understand their practice as operating in a very different sphere from that of science or biomedicine. Myriad practices of healing coexist, straddling the boundaries between imaginaries of modernity and of tradition, borrowing tools, languages, and techniques from old and new, customs and science, some engaging with doctors, while others see their roles and ethos as too different to ever overlap or intermingle. But despite its centrality to everyday healthcare and the ongoing attention of the state, traditional healing in Senegal has not to date been formally regulated. Instead, its everyday legality is largely dependent on the boundaries set by laws on medical practice and on the limits placed on those who are not doctors to provide healthcare. So the legislative proposal that stalled in 2017 would change this, and that has been, sort of the trigger of the controversies. But before looking at this new law itself, I want to briefly describe the peculiarities of the current system. So at the moment, the boundaries of legal healing, let's say, are determined as a result of laws on illegal medical practice and are also negotiated through professional practices and ethics amongst healers. Following those legal and other normative threads, however, suggests some cross-fertilizations, some negotiations between legalities and legitimacies that throw into questions the boundaries of what should be considered as legal effects and what belongs to other kind of social orderings, and indeed the relevance of such distinction between law and other kind of norms. More pertinent, maybe, and cutting across these different orderings is a constant negotiation of traditional healing's social positioning alongside or against biomedicine. Attempts to formally regulate healing also call for a redefinition of this positioning, fueling epistemological and jurisdictional conflicts between state healers, and doctors. So very briefly first, and I want to emphasize this so that we don't reduce the question of regulation of healing to a question of state regulation only. Traditional healing is framed and shaped by a number of shared norms and principles that a majority of healers seem to agree upon, even when their practices might differ otherwise. So to give you just a few examples, being very open about the limits of one's own knowledge is frequently referred to as a key principle of professional ethics, as well as a gauge to determine how honest another healer can be. A general wariness towards those who make significant profit from their healing practice also echoes a shared principle that healers should not in theory, practiced primarily for financial benefit, or as one healer in our interviews put it, real healers are not rich. Such principles can overlap to some extent, to some degree, with tactics employed to avoid being caught in the net of illegal medical practice. For example, the critical outlook of healers we met towards those who extensively advertise the services, as I return to later, is both about ethics and about a broader effort to not openly contradict expectations placed on them by others, doctors, legislators, etc. An expectation that remaining discreet in their practice is important is both presented as a sign of professionalism and as a need to remain tolerated within a legal system that makes the position of healers highly precarious. Centrally, this precarity stems from the legal imperative for healers to not impede on the sphere of medical practice, however fragile the definition of medical practice may be, as we return to, and from the ambivalent interpretations of how laws on illegal medical practice apply to healers. Now, looking at the law itself, the question of illegal medical practice, as I said, is really central to understanding the current limits placed on traditional healings and the sort of things that healers can or cannot do on the everyday. In 1966, so 7 years before its independence, 7 years after its independence, sorry, Senegal adopted a law organizing the legal practice of biomedicine. The law sets out conditions required to practice legally as a doctor. But more importantly for our purpose, it also sets out details of the crime of illegal medical practice. Specifically, anyone who is not a doctor, who takes part in diagnosis or treatment of illnesses or surgical conditions established or suspected, is considered as illegally practicing medicine. And that carries criminal sanctions. The 1966 law is in direct continuation of the colonial period, echoing the language that is still used today in French law around illegal medical practice, and the language that was implemented by the colonial regime in Senegal in 1922. So it has a sort of long history. The potential scope of the phrasing of the law is significantly broader than, for example, legal systems that organize medicine around licensing laws and focus instead on regulating the use of titles and explicit claims to practice medicine. As well as, of course, harmful acts, etc. It's a very broad definition. If you do anything that looks like a diagnosis or offer something that could be considered as treatment, you may be falling under the scope of the law. Now, in theory, at least, much of the activities of traditional healers could be considered as either diagnosis or treatment. And indeed, the Ministry of Health, in its introduction to the 2017 legislative proposal that we return to, begins by stating that the 1966 law does not allow the legal practice of traditional healing in Senegal. In practice, however, traditional healers have been tolerated. They're not hiding it. I mean, it's a very, very common practice. That's largely because they're accepted as part of the cultural landscape, seen as different enough from biomedicine to not get caught entirely by the net of the law. However, there are limitations to what healers can and can't do in order to be seen as remaining within this zone of tolerance. And I want to very briefly explore how the boundary between tolerance and intervention is constructed on the day-to-day. A particular feature of the legal order that I think is relevant to us is that this zone of tolerance is determined through institutional conversations between legal and biomedical institutions. So if prosecutors are able to initiate any action that they see appropriate, denunciations and the trigger for most actions for illegal medical practice mostly originate from the Ordre des Médecins, or the Biomedical Council. They consider that it's part of their role to ensure the safe boundaries of medicine and to draw to the attention of the judicial system any activities that encroaches onto the sphere of their exclusive legal practice. Here, the legal system is inherently dependent on judgments and definitions made by a biomedical professional council, elevated as a quasi-regulatory order beyond its own professional reach. It effectively adjudicates a profession other than that of doctors. Now, following the translations of the law into practice hints at some of the twists and turns that are operated to determine where boundaries of legal professional practice for healers are drawn by doctors. It also illustrates the inherent ambivalence of the relationship between law, medicine, and traditional healing. Traditional healing is caught between its othering from formal healthcare and medical practice and an expectation that it should obey some of its standards and some of the regulatory demands applied to formally regulated medical profession. And I want to illustrate this through two main sorts of friction between the law and medical practice and the activities of traditional healers that kept coming up in our interviews. The first illustrates that if the Ordre des Médecins tolerate traditional healers to some extent, they are keen to ensure that they remain neatly within their own social sphere and don't encroach onto the spaces or tools of biomedicine. This is most visibly illustrated by a particular site of friction. Some contemporary healers, as is actually quite common, keen to use all the resources that they can to understand their patients' conditions, occasionally send them out to undertake biomedical tests, X-rays, blood tests, ultrasounds, etc. They ask their patients to return with the result of the test so that they can then proceed to giving them to offering them traditional remedies. Now, this interference between traditional healers and biomedicine is one that the Ordre des Médecins are particularly keen to stamp down. And the example they use repeatedly in our interviews to illustrate what they saw as the boundary between tolerable healing practice and illegal medical practice. Some healers find this really puzzling. To them, there's nothing to lose from gathering all the information that can be found on a patient's condition, and prescribing blood tests or X-rays or ultrasound is seen as a way to combine the tools of biomedicine with their own knowledge and their potential treatments. They read this reaction from doctors as a form of territoriality and a refusal to enable collaborations between systems. But regardless, healers have sought to adapt to this expectation of doctors in form, if not always in substance. They are cautious in suggesting rather than prescribing medical tests, often ask patients to write down details of the test to be requested rather than write it down themselves, so that it's harder to claim that it was prescribed. And overall, they try to avoid being seen as the ones to initiate a demand for a diagnostic test. Practitioners operate along very fragile lines of legality, and the law itself becomes translated through a tacit form of everyday negotiation. As the president of one association of healers explained, what I try to underline with healers in general is that their problems tend to come from writing diagnosis or recommendations for tests. That's all the Ordre des Médecins are waiting for. As soon as you write that down, they take you to court. Or if you write ultrasound and put your stamp, that's it. They sue you for illegal medical practice, fake professional identity, all of it. Now, the fact that tools of diagnosis are a particularly contentious issue suggests a specific reach to boundary making and illustrates the implication of the law in going beyond a protection against harm. Usually, such boundary setting by biomedical institutions hinges on notions of risk, for example, when products are given as treatment by unqualified practitioners. This is less obvious in this case, where the concern is arguably over an act of knowing rather than an act of doing. Now, this is overtly about protecting patients from the potential harms that non-qualified practitioners may cause, but at the same time, the boundary monitoring at play goes a step further, fostering a more epistemological form of judicial activism. The perception of healers' use of biomedical diagnostic tools as criminal, potentially criminal, suggests that traditional healers are considered as clearly other from biomedicine and expected to remain so. Yet in other respects, their practice within a zone of healthcare means that they are also expected to submit to the laws and regulations that are otherwise imposed on biomedicine, even when they don't formally apply to healing. This shadow of the law creates a more fragile set of norms than the law itself would, fostering an element of normative consensus and expectations between healers, policy, and medical actors, yet not having the same effectiveness as it does on biomedicine itself, because it can't be enforced. Illustrating this is a second set of frictions between some healers and the Ordre des Médecins, but also among healers themselves. And that's the question of advertising, and whether the prohibition of advertising that applies to biomedical practitioners in Senegal should also be seen as having legal implications for healers. Several texts prohibit explicitly advertising in the context of medical practice in Senegal, but those don't apply to healers since they are not considered as doing medicine. Yet, doctors are adamant that this advertising by healers is illegal and a useful flag to determine which healers should be considered as crossing the border of illegal medical practice. Now, unlike the issue of borrowing from biomedical tools, healers tend to agree with doctors that advertising should be rooted out. Their concerns, however, are about legitimacy. Healers who need to advertise their services are not considered serious or professional by others. Not all healers in our interviews attributed this to legal prohibition. Some considered advertising by healers as problematic, but considered that technically they are not acting illegally. They were in a way better informed on this than doctors themselves. Others more bluntly asserted that advertising is prohibited in medicine and that as a consequence, healers are not allowed to use it either. Now, several things are at stake in this ambivalent discourse around advertising and traditional healing. First, the expression of living law, where the text of the law itself may be replaced with a more lively version, embedding some of its principles in daily practices, even where those are not strictly captured by the original scope of the law. Written law is stretched and exceeded by its vernacular interpretation, taken into new direction and forced on groups that it may not initially have targeted. Second, the choreographies at play are about the ambivalence of traditional healing itself between claims of its identity as medical, to the extent that it is expected to submit to some of the rules applied to biomedicine, and as other, to the extent that it's not recognized as equal or equivalent by legal and biomedical institutions. From the perspective of healers, resembling biomedicine and subjecting themselves to the expectations of what professional behavior looks like, and that are also imposed on biomedicine, is important for both internal and external legitimacy. Finally, the restrictions on advertising placed upon medicine also echo professional norms that are shared among healers, in particular their own wariness towards those who seek profit from their healing practice. Here it becomes harder to distinguish to what extent these rules may be influenced by the law or by biomedical practice, and to what extent they just stem from other customary norms that happen to share some elements with state law. Advertising is symbolic of what sets problematic healers apart from genuine ones, as well as a practice that may be damaging to the standing of the healers community towards other communities, including biomedical and legal communities. State law, professional norms, and customary expectations overlap, shaped both by internal and external dynamics, and operate both independently from and in conversation with biomedical professions and their own expectations. Now, against all this background and the sort of many uncertainties that surround the status of traditional healing and in its practice, debates are unfolding on the possibility for the state to formally and directly regulate the field, maybe easing off some of these ambiguities. The drive behind regulating traditional healing partly builds on the state's vision for a more scientific version of traditional healing. But even healers who don't share this drive towards scientization find common ground in the desire to triage traditional healing practice, disentangling genuine, knowledgeable healers from quacks. Across policy actors and healers alike, one effect of the introduction of the law would be to create, symbolically as well as practically, a new role for state agents in relation to the ordering of the field of traditional healing, the sort of, triage between the real healers and the others. Adopted, as we saw already in the Ministerial Council in 2017, the legislative proposal sketches some general principles rather than procedural details about the future of traditional healing. But the principle it embeds already draws certain paths over others, suggesting shift from current practice and in some cases fostering controversy. For example, an immediate effect of the law would be to explicitly legalize the practice of traditional healing, taking out existing doubt and ambiguity about if and when the practice in itself may be constitutive of illegal medical practice. Rather than entirely breaking away from previous practice, the proposed legislation would also entrench some of the boundaries that we've discussed and that currently constitute sites of frictions between healers and the medical council, Advertising by healers would be prohibited, and healers would also be forbidden from writing medical prescriptions for some of the tests we saw. In addition, it creates requirements for the packaging and conditioning of traditional remedies, echoing concerns by the state with the quality of traditional healing products. However, the monitoring of these rules and of traditional healing as a whole would be subject to a new institutional apparatus, and this is where things got really tense. The text proposes the creation of a Conseil national des praticiens de la médecine traditionnelle, a council of traditional healers, that would oversee the application of the law and participate in articulating relevant procedures and criteria further. The law would create a much clearer break from previous practice, shifting the everyday monitoring from the Ordre des médecins and towards a selected group of healers themselves. Maybe unsurprisingly, this has become a real point of tension with the Ordre des médecins. Shortly after its approval by the Ministerial Council and before it was even tabled for a vote in Parliament, the proposed legislation was vehemently and publicly decried by the Ordre des médecins and other healthcare councils. The objections were layered, including substantive objections to what they saw as the legitimation of traditional healers, procedural objections with regard to who had been involved in the drafting of the text and the fact that they had not been involved, and institutional concerns with the creation of the new council. These objections also overlapped and suggest more fundamental tensions around the interface between law and scientific knowledge in healthcare and questions of epistemological control over the provision of care and their institutional implications. So I'll use a couple of quotes from a representative of the Medical Council and the Interrod, so sort of joint council of health practitioners as a whole to illustrate this. This is the problem of the creation of a council of traditional healers. We reacted to this to oppose it and to ask that all actors be involved, not just traditional healers. And by all actors, I mean doctors, pharmacists, dentists, users, everyone. The government will need to justify why they want to create this institution. Another one said, in principle, this draft should have gone through us, or at least the ministry should ask for our opinion on this, because it's hugely significant to adopt rules that are about a medical practice without going through the medical council. For us, this is very serious. No country in the world with any self-respect would do this. We can't adopt a law on medical practice without the opinion of the highest medical institution in the country. Now, the objections raised by doctors and other healthcare professionals suggested both a deep resistance to the idea that traditional healers could be considered a profession, regulated, as is often the case, through rules laid out by the state and enforced by an institutional body of peers, reflecting, for example, the regulation of other healthcare professions. But it also reflects a deep-rooted attachment to the role of the Ordre des médecins as a political actor in the field of public health. The latter, in particular, also echoes the broader ambivalence around what constitutes medical practice that currently plays out in the application of law on illegal medical practice. Traditional healing is considered both as a field of activity that is entirely other from biomedicine and should not impinge on its space of practice. But at the same time, it is seen as a matter for doctors to monitor, adjudicate, and organize. Here, traditional healing is also considered as a subaltern form of care that should not be left to self-organize. For some, this also means that its legitimation by the state as a self-regulating profession is in and of itself problematic and represents a potential threat to the health system as a whole. So as one health regulator put it, if this law is adopted, the health system is going to be turned upside down. We will not accept that our brothers and sisters be put at risk because all those quacks will come along. This concern illustrates the dual significance of the act of regulating, both symbolically and in practice. If for the state of healer, a key effect of the law would be to tidy up the field, order and regulate, effectively to triage the quacks from the real healers, for biomedical actors opposed to it, the law would primarily be about recognizing and legitimizing practices that they see as either inherently problematic or as needing external oversight. Even when biomedical actors accept that traditional healing may have a role to play in Senegal, they expect they should be reframed scientifically, purified, reorganized, and overseen by biomedical knowledge and its agents. In doing so, they also implicitly take the emphasis on science shared by the state a step further, equating such scientific credentials with biomedicine alone, and they exclude the possible coexistence of different types of healing practice, including those that don't align with scientific rationales. Now, around the time when the draft legislation was submitted to Parliament, a group of doctors proposed their own alternative text, articulating a vision under which traditional healing would remain institutionally dependent on biomedicine. Although the text has no legal significance as such, it's been sort of circulated around circles, the biomedical councils and the other relevant professional councils. And it's a thing, it's a sort of shadow law, let's say, that has been sent around. And it's really telling in fleshing out the stakes of the debate and what doctors would like to see if we were to ever regulate traditional healing. It presents some similitude with the ministry's legislative draft, in particular in setting out specific criteria for the legality of practice of traditional healing, banning advertising, banning the use of biomedical tests, etc. But the institutional setup it proposes is, of course, very different, and arguably the most significant difference between the two texts. In the proposal by doctors, traditional healers should be overseen by the Medical Council and subject by the Medical Council's own code of professional practice, rather than administered by a specifically created Council of Traditional Healers as proposed by the ministry. Unsurprisingly, healers who were aware of such demands by doctors opposed them, highlighting why this vision for institutional oversight betrayed a particular understanding of the coexistence of traditional healing and biomedicine. They want to be modern doctors, so that's one of the representative of an association speaking. They want to be modern doctors and control traditional healing. We're going to fight this. We will never accept it. Sorry, that is my son's trumpet teacher ringing for his lesson. They are doing everything they can, but we will not accept it. We need to take care of our medicine. They can look after theirs, and we will look after our own. We need to elect people who work in traditional medicine to oversee our practice, each to their own domain. Overall, in these institutional frictions, two visions of traditional medicine are proposed that are not fully reconcilable. On the one hand, traditional healing is being sketched by the ministry as a field that could potentially be regulated in its own terms through an independent process of professionalization and, in some respect, purification along more scientific lines that would rely on the oversight of selected peers. Agents and institutions of biomedicine are not particularly relevant to this vision. The sphere of practice that they occupy would coexist with that of traditional healers, yet be considered for regulatory and professional purposes as being distinct. This vision is broadly supported by healers, although the difficult question of how and by whom representative peers would be selected has not yet been addressed and is likely to be complex given the very diverse nature of traditional healing and its own internal tensions. On the other hand, medical doctors and other biomedical professionals envisage traditional healing as a subaltern form of quasi-medicine that lacks the credentials to elevate it as an independent sphere of healthcare practice, yet shares sufficient jurisdictional grounds with biomedicine for it to remain under its institutional control. Underlying this position is a rejection of the ontological claims that traditional healers put forward as an alternative to the registers of science and medicine. The problem, of course, is that this is also a position that reflects a status quo in which, as we saw, the position of healers vis-à-vis the law is really ambivalent and very precarious. And while the status quo is, as a consequence, increasingly challenged, it's still not clear whether a consensus can account for the competing visions of legality that are playing out. So I think I will wrap up here so we have some time for questions, and I hope it made some sense.
Thank you, Emily. That was great. I will do some clapping. I'm not sure if other people. It's always difficult on online because I can never find the clap button.
Yes.
So I will give people a few minutes to come up with questions, because usually I will just abuse my privilege as chair and put a fairly basic question to you, and that's in the context of your wider Wellcome Trust project, are you looking at any, not similar, but are you comparing the situation in Senegal with any other situations? For example, debates around regulation of homeopathy in a number of countries, in Canada, in the UK, in Germany, that sort of thing. And I don't want to put you on the spot too much, but is there anything you would feel that you would be happy to talk about in terms of similarities or important differences?
Yes, so no, we are, I mean, comparing, so the other places we're looking at, we are kind of comparing the situation in Senegal with the situation in Ghana, where there's a much longer history of self-regulation by traditional healers, so of actually what the ministry in Senegal is trying to do. But we're also looking at how traditional and alternative medicine, because in Europe it tends to be spoken of as alternative medicine, is regulated in France and in the UK. And then in Mauritius and in La Réunion, which is a French territory abroad. And I mean, the sort of division, so that question of illegal medical practice is also really central in the French context. And so we've been looking at how this sort of, you know, the sort of institutional and knowledge pressures, what is at stake in that idea that doctors have effectively a reach well beyond medicine itself, how that shapes other practices and how that affects, you know, the whole institutional system. And at one level, it's a thing that is, you know, that is not, let's say, always seen as fundamentally different, because all those professions of alternative healers are kind of operating in France and in the UK in ways that are not dissimilar. There you can find a lot of other professions in France, they coexist, they are, I mean, nobody's hiding, there isn't this sort of open sense of illegality, but there's a different kind of precarity, let's say, vis-a-vis the law, and a sort of precarity that plays out there. And like in Senegal, what is really hard is that the terms of how those professions could be organized, and a lot of those professions that are on the sort of on the edge, let's say, of legality, a lot of them want to be regulated and want this sort of triage between the really problematic healers and those that they consider respectable. But a lot of that sort of divisions end up hinging on the definitions given by doctors themselves, right, by biomedicine. And of course, there's also, you know, doctors who do alternative healing in Europe that also creates their own tensions with the biomedical councils, with their peers, etc. I don't know if that answers your question. It's just a sort of long ramble.
No, that's really interesting, and I think that was. I see we've got a question in the chat, so I'm just going to read it out if that's okay. So Pedro, I mean, are you happy for me to read your question out, or do you want to turn your camera on or your sound on and ask yourself? If you don't mind. I'll just read it out, okay? So Pedro says, Emilie, very interesting in your conference. I would like to know which ethical framework in healthcare in general, I think which ethical framework applies to healthcare in general in Senegal. I guess that's, you've talked about legal framework, so I'm not sure whether there's, whether you've looked at any issues around ethics or
no, I mean, I think it's quite a broad question in that there would be different kind of ethical guidance in different elements of healthcare. But as far as doctors are concerned, for example, a lot of it is down to professional regulation. So that same 1966 law that sets the conditions of practice of biomedicine also sets some general principle. The idea that doctors should not be advertising the services, for example, is present in there as well as in other texts. So there's quite a diffuse set of ethical norms, as well as the sort of professional norms that apply to doctors, and you know, the sort of coexistence of healers and I mean, healers are sort of have their own codes of ethics, right? That are not written, that are just shared, that are informal, etc. And some of them reflect those of doctors, some of them don't. And sometimes they also just operate, you know, as the example of advertising shows, I think, in a sort of shadow of those regulations.
Yeah.
I don't know if that entirely answers the question, but do feel free to follow up, Pedro, if you'd like.
Sure. So we also have a question from Liliana. I'm just going to quickly go to Jane because I know Jane has something out immediately after this. So if Jane, if you would like to unmute.
Thank you, Michael. Thank you for a fabulous presentation. I was just really interested in the way that you've analysed the law and the way that the law actually can stipulate what is appropriate behaviour and what isn't, and how it's done this in terms of healers and in terms of medical doctors. And I was just wondering how much of that is part of a colonial history, which is also bringing in Western type medicine and actually then putting traditional medicine into the other. And I was just wondering if you think that's part of the narrative in this situation.
I think it's absolutely part of the, you know, part of the context. It's never, it comes as it's the official narrative. It's the narrative that some healers spell out. They very much experience it like this, basically, as this is, you know, we've just inherited this idea that modern Western medicine is superior to ours, and they very much articulate this. The doctors and the state don't really articulate it in this way, of course. However, the history, so the history in Senegal, like in much of Africa, is one of, you know, the colonial powers coming and pushing away traditional medicine in all sorts of ways, and placing it very clearly as a subaltern type of practice. In Senegal and in other former French colonies, what is particular is, you know, the sort of inheritance of the laws, so the laws on illegal medicine, illegal medical practice, which are, you know, still the instrument we use in France, and a very blunt instrument that really shapes, you know, what people can do even when they're not regulated, but also the institutional, you know, the institutional inheritance, so the sort of political weight of the Ordre des Médecins is again very similar to what we see in France, of the sort of, you know, it's not just a professional, they don't just do professional regulation, they also really have a voice as the sort of authority in determining what is acceptable knowledge or not. And that stretches to things that actually medical doctors are not really, you know, able to do, because traditional medicine itself is so complex and its own, you know, its own thing. But, you know, absolutely, this is, you know, the whole system is inherited from colonial history and very heavily shaped by that.
Yes, it's very interesting, isn't it? Who makes the law, and how decisions are made, and what the law covers. So it's sort of this tolerance of healers, and I like the way you described it as being in the shadow of the law. Is that how you described it? And it's I think what your case study does is actually really illustrate the way that law is operating, and you know, kind of all of the way that power is activated and enacted through legal precedent and through statute and all of these things. And so it's really important that we're really critical about where law is coming from, and who's making it, and what are seen as the problems or what are seen as the priorities. Says a lot about a society and its history and context.
Yes, absolutely. So, no, you're absolutely right. And, you know, and there, I think in this case today, we can see both the, you know, how it's made, like how the law is now being made and contested, and when it can't be made because the state is trying. And actually, you know, this law has not been talked about since there was the sort of you know, protest of doctors, but also how sort of very open, I mean, the law as it stands is so open and so heavily delegated to doctors to adjudicate that they get to decide what is legal or is not legal, and they get to set those terms. So yeah, it's
very interesting. Thank you.
So we have another question in the chat from Liliana, who wanted to know whether people who accept and use traditional medicine, whether they also accepted the COVID vaccination, if in fact it was actually available to them.
Yes, I think that is probably the bigger question, the question of availability. I mean, I can't answer that precisely and with authority, but what I would say is that in places where traditional medicine is so common and used, you know, such part of everyday routine health care, people are not opposed to modern medicine. So patients navigate those systems in different ways. They may turn to traditional medicine for some kind of ailments and then turn to doctors for other kind, or go to the hospital for other things. They may start from the hospital, and then if that doesn't work, go to traditional healers, or vice versa. So there's really not a relationship of exclusion. And actually the healers we spoke to were themselves, very clear about the fact that they want to do certain things, but they're not doing the same thing as doctors. And in a way, their attempts to send people for blood tests and for, x-rays and all that shows that they don't see the systems as being, opposed. You don't have to reject modern medicine in order to use traditional medicine, or vice versa. But the problem of modern medicine may be precisely that, the wrong discourse may make patients feel that they have to choose. And, again, going back to your question, Michael, I think that's what we found in other examples, and maybe some of the things that we see with some elements of people feeling, pushed away from distrusting biomedicine in general, which leads to resistance to vaccine and to other things. Is that the more people want to be able to navigate to some extent between systems, and if they feel that one system is imposing its truth and its exclusive truth on them, then they sometimes get more resistant than they would otherwise. But as far as I know, people do navigate quite commonly the systems.
Yeah. So I have another question, if that's okay.
Yes.
We were talking about the precarity of traditional healers. I was just wondering, to what extent does that precarity also extend to questions of liability? So we know medical liability obviously applies to sort of biomedical doctors and practitioners. But because there is this ambivalence, sometimes they want to see traditional medicine as being within their remit, and sometimes they want to say, no, it's really outside, and it's almost this boundary object. What happens in cases of liability? So does it come under a medical type of liability, or does it come under more like a criminal type of liability for causing harm to someone?
Yeah, no, so for actual harmful acts or death or whatever, it would fall under standard criminal law, because technically they are not bound by what may happen is that they are also then considered as having committed the crime of illegal medical practice on top of that, right? So when that will be used is sort of triggered by certain things, and harm is going to be one of those things.
So does that, I mean, I'm just wondering, there's a lot of ontological hoops there to say that they, in a way, they're saying an illegal medical practice also includes practices that are not medical, in a sense. If you call something medical, but a biomedical scientist doesn't believe that it is medical, they're still saying that could be treated as an illegal. I mean, that's. I guess it's like an unscientific medical practice from a biomedical standpoint, but.
Yes, and it's sort of unable, it's very unsettling. So it's, the same in France, actually, when you follow the law on illegal medical practice there, that in France you can, so alternative medicines in France can be practiced, but technically only by doctors, right? So only a doctor can
Right.
legally prescribed homeopathy, etc. So you get into that sort of situation where only doctors can legally do things other than medicine, which just that, as you said, is all those ontological hoops in trying to figure out what is at stake, and there's all kind of reasoning behind that. But that sort of definition of, okay, you know, it is kind of seen as medicine and it's kind of not. It's technically enabled by the very broad phrasing of the law, right? So because it says diagnosis, treatment, imaginary or real or whatever, like, you know, you've got this very broad phrasing, means that you can say, well, this was given as a treatment. It was never going to work, but it was given as a treatment. But at the same time, it creates this really, you know, strange ontological situation where, you know, things can navigate in and out. It's considered as having been medicine. It is, and you can see it in the quotes, you know, in some of the ones I use, but in plenty of others, where doctors will go from saying, you know, this is just quackery, this is nothing, to saying, well, this is a medical practice, we need to oversee it. So there's a lot of real
I mean, I guess it's sort of on the flip side. I suppose it means there's a much stronger legal foundation for prosecuting fraudulent biomedical practices. So if, you know, I'm thinking about things like, and I don't know whether this would be available in Senegal, but, you know, people setting up private clinics for stem cell therapy with not necessarily. So I mean, it plays differently in different places, but we did have situations, for example, in Australia, where people had no medical license, but they were saying it's not a medicinal product. It's like a mild surgical intervention, and so we can provide it without any oversight. And we're, you know, you could only be prosecuted if someone brought a complaint against them. And they, you know, and so most of the people who received it didn't want to complain because, in a sense, they very much bought into the idea that this might help them, and sometimes you they'd put a lot of into it. And in one, I'm not sure. I know Cameron Stewart. I don't know if do you know him? He's a professor at Sydney. Sorry, he's a professor of law at Sydney, but he was looking into this a lot in Australia, and he had some very interesting stories of kind of illegal physicians actually basically just going around to threaten patients not to sue them. So I suppose there's always spillovers from the law. It's kind of, it always has some sort of shadow or some, as you said,
yes, it does.
Law where people interpret it or say act influenced by what they think it means or what they think it means.
I'm looking at the comment.
Sure. Yeah.
What's the people Senegal in Buenos Aires? Oh, that's interesting. Yeah, I mean, I think there's a big diaspora of you know, of Senegalese people in quite a lot of places, actually, all around the world. I think, in like migration in general, a lot of that is for economic reasons, for looking for work, and the lack of healthcare is relative in Senegal, like everywhere else. People do, you know, have some access, and actually, it's probably better than a lot of African countries, but as we've seen with the sort of vaccine access issues, it's still very limited, and it's still very dependent on whether you live in a sort of more accessible city or in a remote village or whatever. And I think people also turn to healers for a variety of not having access to other healthcare, but also just because that's what they want to do. They find it useful. It works, right? It works, and that's you know, always the ambivalence as well. I mean, we didn't get to talk very much about the questions of evidence and pathology in that respect, but there's also that issue, and that comes up a little bit in Senegal when it comes to that idea by the state of triaging the scientifically proven from the not scientifically proven. That's really hard to do when you get into those things that don't prove in the way science does. And you know, it kind of works for plants to some extent, but you know, people will say, well, even plants, if you isolate them from the ritual or from something else, it won't work in quite the same way.
Yeah.
So it.
I mean, in a way, it almost seems like there's potentially clear more overlaps with kind of, psychological therapies and things like that. It's very difficult to do a sort of clinical trial, of, especially a kind of psychoanalytic therapy or anything like that. If it's a medicinal product, just you have a radically different standard of evidence because of the.
Yes. And I think in relation to alternative and traditional medicine, that has been done in some places. So in some countries, you have sort of different systems of evidence, etc. But a lot of it still remains, and there's a lot of push and demand to use things differently. But that's not really been put in place in the way people demand. So there's still, it's still you may deviate a little bit from the scientific. But once you let go of them, it's not quite clear what else is there. And to come back, to that question of professional boundaries and what medicine can do and what doctors can get away with, etc. The sort of other side of the coin, which of course in Senegal doesn't play out in the same way because it's really traditional healing that's talked about now. But plays out in France is how do you set the boundaries of what medical doctors can do? So in France, the medical council that is, quite conservative in its views in general and many things, is under a lot of pressure to explicitly forbid doctors from using homeopathy or other things, right? So that's that sort of space. And for now, those practices have navigated a bit with some doctors offering them a bit sort of informally, etc. But of course, the more you forbid, the more things go under the radar. So there's also that question of what happens when you don't regulate or you just criminalize or prohibit something.
That's again, that's another possible spillover. It's like it shows you. I mean, I guess it's a good illustration of how it's really difficult to make good law that does what you want it and doesn't do, too many undesirable things.
Yes,
the balance
absolutely. And because in this field we are, we tend to, as long when we use scientific standards to prove things, it works to some extent. I mean, not for everything, not things like, surgery is very hard to, that's another example. So there's some things that don't quite work, but usually, you kind of, but when you let go, if you have to let go of that, then it becomes really, really hard to set boundaries and
yeah. Well, thank you very much, Emilie. That was
thank you, Michael.
Really interesting discussion
for the
as well.
question.
So, I think for the people who are left, obviously a few people had to drop off, but let's just take a moment to thank Emilie again. I can see a few claps coming up.
Thank you very much.
So.
And